General Theory of Law and State by Hans Kelsen. Quotes. General Theory of Law and State by Hans Kelsen is a foundational exploration of legal and political theory that introduces Kelsen's pure theory of law. This book seeks to articulate a comprehensive view of how legal systems operate independently of moral or political ideologies, emphasizing the need to distinguish between is, what the law is, and ought, what the law should be. Kelsen carefully analyzes the hierarchy of legal norms, the role of the state as a central legal order, and the dynamic processes by which laws are created and applied. His work challenges readers to see law as a scientifically organized system of norms that function according to established rules and structures, without the interference of subjective values or ideologies. Quote 1. The concept of a legal person, who, by definition, is the subject of legal duties and legal rights, answers the need of imagining a bearer of the rights and duties. Kelsen explains that the legal person is a construct used to organize legal rights and duties. The legal system requires an entity to be the bearer of rights and obligations, and the concept of a legal person fulfills this role. This concept is not a real, independent entity, but rather a convenient way for juristic thinking to treat a set of legal norms as if they belong to a distinct subject, whether it be a human being or a corporation. This abstraction helps manage the complexity of legal rights and duties by attributing them to a single, unified subject. Quote 2. In reality, however, the legal person is not a separate entity besides its duties and rights, but only their personified unity. Kelsen emphasizes that legal persons do not exist apart from the rights and duties they represent. The legal person is simply a way to personify a set of legal norms, giving them a cohesive form. This challenges the common perception of legal persons as real entities that possess rights and duties. Instead, they are a symbolic representation that organizes and unifies legal obligations and privileges, serving as a tool for managing the legal system's complexity, without suggesting an independent existence beyond these norms. Quote 3. The physical person, as the subject of duties and rights, is not the human being whose conduct is the contents of these duties or the object of these rights, but the personification of these duties and rights. Kelsen clarifies that a physical person, in legal terms, is not simply a human being, but the personification of the legal norms that apply to them. The legal system creates this distinction to separate the biological individual from the legal construct that is responsible for rights and duties. The physical person is thus a juristic creation, a way to bundle legal responsibilities and entitlements under one name, separate from the natural human being. Quote 4. The typical case of a juristic person, in the narrower technical sense, is a corporation. Kelsen introduces the corporation as the classic example of a juristic person. A corporation is a group of individuals treated as a single legal entity, with its own rights and duties, separate from those of its individual members. This legal treatment allows corporations to own property, enter into contracts, and be held responsible for legal obligations independently of the individuals within it. This demonstrates the flexibility of the legal system in creating entities that can act and be treated as unified persons for the purposes of law, despite being composed of multiple individuals. Quote 5. It cannot be seriously denied that actions and forbearances can only be actions and forbearances of a human being. Kelsen points out that while we speak of corporations acting or making decisions, in reality, only human beings can perform actions or make choices. Any reference to a juristic person acting is, in fact, a reference to the actions of individuals who represent the corporation. This shows that the legal fiction of corporate personhood simplifies complex relationships by attributing actions and decisions to an abstract entity, but ultimately it is human beings who are responsible for carrying out those actions. Quote 6. The imputation of the action or forbearance of an individual to the community concerns the relation of a fact to the legal order determining this fact in a specific way. Kelsen explains the concept of imputation in the context of corporations, where the actions of individuals are legally attributed to the collective entity. This legal construction allows the corporation to be treated as the actor, even though it is individuals who perform the actual actions. The legal system imputes these actions to the corporation, framing the collective as a singular entity that can be held accountable or benefit from legal outcomes, highlighting how the legal order organizes and processes collective behavior. Quote 7. The juristic person, in the narrower sense of the term, is nothing but the personification of an order regulating the behavior of several individuals. Kelsen describes the juristic person as the personification of a legal order that governs the behavior of multiple individuals. This collective structure, such as a corporation, is given a unified identity by the legal system, allowing it to function as a single entity. This abstraction simplifies the management of legal responsibilities and entitlements by grouping individual actions under one name, making the legal system more efficient in regulating the conduct of groups or organizations. The personification allows for the application of legal norms to what is essentially a structured group of human beings. Quote 8. That the law of the state gives a juristic person rights and duties does not mean that a being other than a human individual is obligated or authorized. It only means that duties and rights are indirectly given to individuals. Kelsen clarifies that when the law confers rights or imposes duties on a juristic person, such as a corporation, it is ultimately human individuals who are bound by or benefit from these legal provisions. The corporation itself cannot act independently of its members, and any rights or duties attributed to it are, in fact, borne by the individuals acting on its behalf. This shows that the legal person is a tool to organize collective actions and responsibilities, but the actual execution of those actions is always performed by people. Quote 9. The legal order is a system of norms. The question then arises, what is it that makes a system out of a multitude of norms? Kelsen begins by emphasizing that a legal order is composed of multiple norms. The challenge lies in understanding what unifies these norms into a coherent system. This question is essential because legal norms do not exist in isolation. They function as part of an organized structure where each norm derives its validity from its place within the system. Kelsen suggests that the unity of the legal order is established through a hierarchy of norms, culminating in a basic norm, which serves as the foundation of the system. Quote 10. The reason for the validity of a norm is always a norm, not a fact. Here, Kelsen asserts that norms derive their validity from other norms, not from factual circumstances. This means that legal norms are justified by their relationship to higher norms within the system, rather than by external realities. The validity of a norm is not determined by whether it corresponds to facts, but by whether it follows from a superior norm. This reinforces Kelsen's idea of a legal order as a self-contained normative structure, where the justification for one norm is always found in another, leading up to the basic norm. Quote 11. A norm the validity of which cannot be derived from a superior norm we call a basic norm. Kelsen introduces the concept of the basic norm, which is the foundation of any legal system. The basic norm is the ultimate source of validity for all other norms within the legal order. It cannot itself be derived from a higher norm, making it the starting point for the entire normative structure. This basic norm is presupposed to be valid and serves as the underlying principle that legitimizes the legal order as a whole. It is the cornerstone that gives coherence to the system of norms. Quote 12. The system of norms we call a legal order is a system of the dynamic kind. Kelsen explains that a legal order is dynamic, meaning that it is constantly evolving through the creation and annulment of norms. Unlike static systems, where norms are fixed and unchanging, legal norms are produced and modified by authorized entities, such as legislatures, courts, or other legal bodies. This dynamism allows the legal system to adapt to changing circumstances while maintaining its internal coherence. The process of norm creation follows the rules established by the legal order, ensuring that each new norm fits within the overall structure. Quote 13. The validity of a legal norm cannot be questioned on the ground that its contents are incompatible with some moral or political value. Kelsen argues that legal norms are valid purely by virtue of their creation according to the rules of the legal system, not because they conform to moral or political ideals. This separation of law from morality is a key element of Kelsen's legal positivism. The law is autonomous and operates independently of ethical or political considerations. A norm is valid if it has been created in accordance with the legal order, regardless of whether it aligns with any particular set of values. This reinforces the idea that the legal system is a self-contained structure. Quote 14. A revolution, in this wide sense, occurs whenever the legal order of a community is nullified and replaced by a new order in an illegitimate way. Kelsen defines revolution broadly as any situation in which a legal order is overthrown and replaced by another in a way not prescribed by the previous order. The new legal order does not arise from within the framework of the old one, and its legitimacy depends on its ability to establish itself and gain acceptance. Once the new order becomes effective and widely observed, it is considered valid, regardless of how it came into being. This shows Kelsen's focus on the effectiveness of a legal system as a crucial factor in its legitimacy. Quote 15. The efficacy of the entire legal order is a necessary condition for the validity of every single norm of the order. Kelsen explains that for any individual legal norm to be valid, the entire legal order to which it belongs must be effective. If the legal order ceases to function or loses its effectiveness, the norms within it also lose their validity. However, effectiveness alone does not confer validity. The norms must also be created according to the rules of the legal order. This highlights the dual importance of both procedural correctness and practical efficacy in maintaining the validity of legal norms. Quote 16. Law cannot exist without power. Still, law and power, right and might, are not the same. Law is, according to the theory here presented, a specific order or organization of power. Kelsen acknowledges that law is deeply intertwined with power, but he insists that they are not identical. While law requires power to enforce its norms and maintain its authority, it remains distinct because it represents an organized and structured system of rules. Power without law is mere force, but law organizes and channels power in a way that is consistent with the norms of the legal system. This distinction emphasizes the importance of law as an institution that both regulates and legitimizes the use of power. Quote 17. The basic norm is only the necessary presupposition of any positivistic interpretation of the legal material. Kelsen states that the basic norm is an essential assumption for interpreting the legal system within the framework of legal positivism. It is not created by any legal procedure, but it must be presupposed to make sense of the legal system as a coherent structure. The basic norm provides the foundation for understanding the creation and validity of legal norms, allowing jurists to analyze legal systems without invoking moral or metaphysical justifications. This underscores the central role of the basic norm in maintaining the internal logic of a legal order. Quote 18. The legal transaction is an act by which the individuals authorized by the legal order regulate certain relations legally. Kelsen explains that legal transactions, such as contracts, allow individuals to regulate their own legal relations within the framework established by the legal order. These transactions create legal duties and rights between the parties involved, making them law-creating acts. Legal transactions thus provide individuals with a degree of autonomy, as they can create binding obligations for themselves through agreements. This highlights how individuals engage with the legal system not only as subjects of pre-existing norms, but also as active participants in the creation of law through their transactions. Quote 19. It is in the law-creating function of the legal transaction that the so-called private autonomy of the parties manifests itself. Kelsen emphasizes that private autonomy in legal systems is expressed through the ability of individuals to create their own legal obligations and rights through contracts or other legal transactions. This autonomy allows individuals to have control over their legal relations, demonstrating the legal system's recognition of personal freedom in the realm of private law. By entering into agreements, individuals participate in the creation of norms that are specific to their relationships, reflecting their capacity to shape the legal landscape within the boundaries of the broader legal order. Quote 20. By entering a legal transaction, they apply these general legal norms. Kelsen explains that when individuals engage in legal transactions, they are applying pre-existing general legal norms to their specific circumstances. The legal system provides the framework within which such transactions can occur, and by entering into agreements, individuals utilize this framework. Thus, legal transactions are not entirely independent acts, but are embedded within the broader legal structure, as the norms created by the parties must conform to the general legal rules governing contracts and obligations. Quote 21. A specific law-creating act must be added to the general norm, a legal transaction by which an individual secondary norm is created. Kelsen points out that general legal norms do not directly stipulate the specific obligations of parties in a contract. Instead, a legal transaction, such as the creation of a contract, is needed to establish specific duties and rights between the parties. This transaction gives rise to an individual secondary norm that operates in conjunction with the general norm, creating a concrete set of obligations that apply to the individuals involved. This underscores the dynamic nature of the legal system, where general norms provide the foundation for the creation of individualized legal duties. Quote 22. The legal transaction is a law-creating fact. The delict is not. Kelsen contrasts legal transactions with delicts, wrongful acts, explaining that legal transactions intentionally create legal consequences, such as rights and obligations, whereas delicts do not. Delicts trigger sanctions, but they are not intended to create legal norms in the way that transactions do. Legal transactions are purposeful acts aimed at establishing legal relationships, while delicts are typically violations of the law that lead to enforcement actions. This distinction highlights the different roles these two types of acts play in the legal order, with transactions fostering legal order and delicts disrupting it. Quote 23. The norm created by the contract may be individual or general. Kelsen explains that contracts can create either individual norms, which apply specifically to the parties involved, or general norms, which have broader applicability. In some cases, especially in labor or international law, contracts may establish general rules that affect a larger group of people beyond the immediate parties. This demonstrates the flexibility of legal transactions in shaping both private and public legal relations, depending on the scope and intent of the agreement. The ability to create either individual or general norms through contracts reinforces the active role of legal transactions in structuring societal interactions. Quote 24. A contract is a two-sided legal act, insofar as the secondary norm, obligating and authorizing the contracting parties, is created by the collaboration of at least two individuals. Kelsen describes the bilateral nature of contracts, where both parties collaborate to create a norm that binds them. This mutual agreement results in the creation of legal duties and rights, making the contract a two-sided legal act. The involvement of both parties ensures that the resulting legal obligations are a product of consensus, reflecting the principle of private autonomy. This bilateral creation of norms distinguishes contracts from other types of legal acts, where obligations might be imposed unilaterally or by external legal authority. Quote 25. Courts are creators of general legal norms. Kelsen emphasizes that courts, in addition to applying existing law, also create new legal norms. Judicial decisions, particularly those that serve as precedents, can establish general norms that influence future cases. This highlights the dynamic role courts play in shaping the legal system, not merely by interpreting laws, but by contributing to their evolution. Courts thus function as legislative organs, in the sense that they produce binding legal norms through their rulings, expanding the scope of law beyond what was originally enacted by legislatures. Quote 26. Our analysis of the judicial function shows that the view according to which the courts merely apply law is not borne out by the facts. Kelsen argues against the traditional view that courts simply apply pre-existing laws to cases. His analysis reveals that courts often engage in lawmaking, particularly when they interpret statutes or create precedents. This challenges the notion of a rigid separation between the legislative and judicial functions, as judicial decisions often extend or refine the application of law, effectively creating new legal rules. Kelsen's observation underscores the active and creative role of courts in the legal system. Quote 27. The judicial decision may have the character of a precedent, i.e., of a decision binding upon the future decision of all similar cases. Kelsen explains that when a judicial decision serves as a precedent, it establishes a general legal norm that must be followed in similar future cases. This process of precedent setting allows courts to play a central role in the development of legal norms over time. Precedents ensure consistency in legal rulings, as future decisions are guided by the principles established in earlier cases. This system reinforces the continuity of the legal order while also allowing it to adapt to new situations through judicial interpretation. Quote 28. It is difficult to understand why the words of a statute, which, according to its meaning, is binding upon the courts, should be dead, whereas the words of a judicial decision which, according to its meaning, is binding upon the parties, should be living. Kelsen critiques the idea that statutes are passive or dead until interpreted by courts, while judicial decisions are considered active or living. He argues that both statutes and judicial decisions have binding force and are equally part of the legal system. The act of interpretation by courts does not make statutes any less authoritative. Rather, it ensures that they are applied appropriately. This highlights Kelsen's belief in the equal importance of both legislative acts and judicial decisions in creating and enforcing legal norms. Quote 29. The higher norm, the statute or a norm of customary law, determines to a great extent the creation and the contents of the lower norm of the judicial decision. Kelsen emphasizes the hierarchical structure of the legal system, where higher norms, such as statutes or customary law, guide the creation and content of lower norms, including judicial decisions. This relationship ensures that judicial rulings are grounded in the broader legal framework, maintaining consistency and coherence within the legal order. However, the judicial decision also introduces new elements to the legal system, demonstrating the balance between adherence to higher norms and the creative role of courts in shaping legal outcomes. Quote 30. The possibility that the lower norm does not correspond to the higher norm, which determines the former's creation and content, is not at all excluded. Kelsen acknowledges that there is always a possibility that judicial decisions, lower norms, may not fully align with the statutes or customary laws, higher norms, they are based on. This discord can arise due to differences in interpretation or the application of general legal principles to specific cases. However, mechanisms such as appeals and higher courts exist to resolve these discrepancies, ensuring that the legal system functions with a degree of flexibility while still striving for alignment between different levels of norms. Quote 31. The legal order cannot have any gaps. Kelsen asserts that the legal system is designed to cover all possible situations, meaning there can be no gaps in the law. Even if no specific law applies to a particular case, courts are empowered to interpret existing laws or create new norms to resolve the issue. This ensures that the legal system can address all disputes and provides a basis for judicial decisions even in novel circumstances. The concept of gaps in law is, therefore, a fiction used to justify judicial creativity when existing laws do not clearly apply. Quote 32. A legal norm is always valid. It cannot be null, but it can be annulled. Kelsen explains that legal norms are valid until they are actively annulled by a competent authority. Even if a norm is found to be inconsistent with higher legal principles, it remains legally binding until it is formally annulled through the proper legal process. This distinction between nullity and annulment reinforces the principle that all legal norms hold validity within the system unless and until they are overturned by an authorized organ. This ensures stability in the legal order, even in cases of conflict between norms. Quote 33. Only the legal order itself could answer that question. Kelsen emphasizes that questions about the validity or annulment of legal norms can only be resolved by the legal system itself, through its established processes and organs. This underscores the self-contained nature of the legal order, where internal mechanisms determine the resolution of conflicts or ambiguities within the system. Legal norms derive their authority from the legal order, and only through this order can their validity be challenged or upheld. This reflects Kelsen's belief in the autonomy and self-regulation of legal systems. Quote 34. Since about the beginning of this century, the demand for another theory of law has been raised. A theory is asked for which describes what people actually do, and not what they ought to do. Kelsen notes the rise of a competing view of law, which calls for a theory that focuses on actual human behavior rather than normative rules. This approach, often associated with sociological or realistic jurisprudence, argues that law should be studied based on how people behave in practice, much like the laws of nature describe physical phenomena. This shift towards empiricism challenges the traditional view that law is primarily about prescribing behavior rather than describing it. Quote 35. Like any other empirical science, normative jurisprudence describes its particular object, but its object is norms and not patterns of actual behavior. Kelsen defends his normative theory of law, comparing it to empirical sciences in its method of describing its subject matter. However, he clarifies that while natural sciences describe actual behavior and events, normative jurisprudence deals with legal norms, rules that prescribe how people ought to act, not how they actually do act. This distinction between describing what is, empirical facts, and what ought to be, norms, is central to Kelsen's approach, emphasizing the prescriptive nature of law. Quote 36. The statements by which normative jurisprudence describes law are different from the statements by which a sociology of law describes its object. Kelsen highlights the fundamental difference between normative jurisprudence and sociological jurisprudence. The former focuses on legal norms and uses ought statements to describe how individuals should behave according to the law. In contrast, sociological jurisprudence uses is statements to describe how people actually behave, based on empirical observations. This distinction underscores the different goals and methods of these two approaches. Normative jurisprudence is prescriptive, while sociological jurisprudence is descriptive. Quote 37. The difference between natural science and normative jurisprudence does not consist in the logical structure of the statements by which both sciences describe their respective objects, but in the specific sense of the description. Kelsen argues that both natural science and normative jurisprudence share a similar structure in their statements. They both use conditional statements that connect a cause with an effect. However, the key difference lies in the meaning of these. In natural science, the cause leads to an effect as a matter of fact, is, while in jurisprudence, the condition leads to a required action, ought. This comparison emphasizes that while both fields describe systems of rules, the nature of the connections within those systems differs fundamentally. Quote 38. A legal duty so called is nothing but a prediction. What if a man does or omits certain things, he will be made to suffer in this or that way by judgment of the court. Kelsen refers to Oliver Wendell Holmes's view of law as essentially a system of predictions about what will happen if someone breaks the law. According to this perspective, legal duties are not abstract obligations but practical predictions about the consequences of certain actions, specifically whether a court will impose a sanction. This pragmatic view reduces law to a tool for forecasting the behavior of legal institutions, focusing on the actual consequences of legal decisions rather than on the abstract ought of legal norms. Quote 39. The difference between the juristic and the sociological definitions of duty and right that we occasionally find Austin employing the sociological definitions without his being aware of having abandoned his specific juristic method. Kelsen notes that, even within juristic traditions, like those of Austin, there is sometimes confusion between normative and sociological approaches. Austin, at times, adopts a sociological view of legal duties and rights, framing them in terms of probabilities and outcomes, such as the likelihood of punishment, rather than as normative obligations. This blending of approaches highlights the tension between viewing law as a system of norms and as a description of social behaviors or institutional practices. Quote 40. The law which courts apply is no scientific treatise describing and explaining actual facts. It is not a system of theorems which are the product of scientific cognition, but a set of prescriptions regulating the behavior of the subjects and organs of the legal community. Kelsen emphasizes that law, unlike science, does not aim to describe facts or explain natural phenomena. Instead, it prescribes how people and institutions should behave. Law is a system of rules created by acts of will, designed to guide behavior and organize society, not a collection of truths about the world. This distinction reinforces the idea that law is fundamentally about shaping human actions through norms, rather than explaining existing patterns of behavior. Quote 41. The theory of law which has been presented here is a juristic theory, allowance being made for the tautology. It shows the law to be a system of valid norms. Kelsen introduces his juristic theory of law, emphasizing that it views law as a structured system of valid norms. Unlike sociological approaches, which may focus on how people behave, this theory concentrates on the validity and structure of legal norms themselves. Kelsen's theory treats law as a normative system, where the key concern is how norms are created, structured, and maintained, rather than how they are followed or enforced in practice. This distinction sets normative jurisprudence apart from empirical or sociological perspectives. Quote 42. Sociological jurisprudence presupposes the normative concept of law. Kelsen asserts that even sociological jurisprudence, which focuses on actual behavior, relies on the normative concept of law. This means that, even when studying law as a social phenomenon, one framework of norms established by legal theory. Law exists as a set of norms in the minds of individuals, shaping how they behave in relation to those norms. Sociological studies of law must still refer to this normative framework to distinguish lawful behavior from unlawful actions, even if their focus is on real-world practices. Quote 43. The significance of the statement, A is legally obliged to certain behavior, is not, it is probable that a court will enact a sanction against A, but, if a court establishes that A has behaved in the opposite way, then it ought to order a sanction against A. Kelsen clarifies the distinction between normative and sociological interpretations of legal obligations. Normative jurisprudence states what ought to happen. If someone violates the law, a court ought to impose a sanction. This differs from sociological views, which might focus on the likelihood of a sanction being imposed in practice. Kelsen's point underscores the importance of understanding law as a system of obligations that courts are supposed to enforce, not just as a prediction of what might happen in reality. Quote 44. A sociology of law is required, which describes law in terms of real rules, not of ought rules or paper rules. Kelsen describes the push for a sociological approach to law that focuses on the real rules that govern behavior in society, rather than the formal norms laid out in legal texts. This view critiques traditional legal theories for focusing too much on what the law says, the ought, and not enough on how it operates in practice. Sociological jurisprudence seeks to bridge this gap by studying how laws are actually applied and followed in real-life contexts, contrasting with normative theories that are more concerned with the ideal operation of legal norms. Quote 45. Human behavior pertains to the domain of the sociology of law not because it is oriented to the legal order, but because it is determined by a legal norm as condition or consequence. Kelsen explains that human behavior becomes relevant to the sociology of law when it is shaped by legal norms, regardless of whether individuals consciously orient their actions to those norms. This distinction broadens the scope of sociological jurisprudence to include behavior that is influenced by law. Individuals do not explicitly think about the legal norms governing their actions. Legal norms determine the consequences of behavior, making that behavior a subject of sociological analysis, insofar as it relates to the legal system. Quote 46. The law exists as such a body of valid norms in the minds of individuals, and the idea of law causes or accompanies their behavior. Kelsen emphasizes that law is not just an external system of rules, but also exists in the consciousness of individuals. People behave according to the law because they internalize the idea of a valid legal order. This mental framework influences how they act in relation to legal norms, making the law not just a set of external commands, but also a guiding principle that shapes human behavior. This connection between law and individual consciousness is key to understanding how legal norms function both practically and normatively. Quote 47. Only by referring the human behavior to law as a system of valid norms, to law as defined by normative jurisprudence, is sociological jurisprudence able to delimit its specific object from that of general sociology. Kelsen argues that the sociology of law can only distinguish itself from general sociology by referring to the normative concept of law. While general sociology may study any form of human behavior, sociological jurisprudence focuses specifically on behavior that is influenced by legal norms. This makes legal norms the defining characteristic of sociological studies of law, allowing scholars to differentiate between legally relevant behavior and other forms of social interaction. Without this normative reference, sociological jurisprudence would lose its distinct focus on the role of law in shaping behavior. Quote 48. The state, as a legal community, is not something apart from its legal order, any more than the corporation is distinct from its constitutive order. Kelsen argues that the state is inseparable from its legal order, much like a corporation cannot exist apart from the legal norms that create and regulate it. The state is a legal entity that exists solely through the legal framework that defines and sustains it. It is not an independent social or physical entity, but rather a personification of the legal system itself. This challenges the traditional view that the state and law are two separate entities, suggesting instead that the state is simply the embodiment of its legal order. Quote 49. The state is the community created by a national legal order. The state, as juristic person, is a personification of this community, or the national legal order constituting this community. Kelsen defines the state as a community brought into existence by a national legal order, emphasizing that the state is not an abstract entity, but the personification of the legal system that governs its citizens. In this sense, the state is identified with the legal norms that regulate the behavior of individuals within a given territory. This explanation underscores that the state's existence is entirely dependent on the legal framework that defines and organizes it, rather than being an autonomous social or political reality. Quote 50. The interaction between individuals belonging to the same state is more intense than the interaction between individuals belonging to different states. Kelsen critiques the sociological idea that the state is defined by the intensity of interaction among its members, explaining that this view is overly simplistic. While some argue that citizens of the same state interact more with each other than with those from other states, Kelsen points out that in many cases, individuals may have stronger ties with people in different states due to cultural, economic, or personal factors. This critique emphasizes that social interaction alone cannot define the state. Instead, it is the legal order that provides the true foundation of statehood. Quote 51. The state, as politically organized society, is an order regulating the use of force, because it monopolizes the use of force. Kelsen explains that the state's political nature stems from its ability to regulate and monopolize the use of force. The legal system gives the state the authority to control coercive power, making the state a political organization in which force is used according to legal rules. This legal regulation of force distinguishes the state from other forms of social organization and underscores its function as the enforcer of law. The state's monopoly on legitimate coercion is a defining characteristic of its legal and political structure. Quote 52. Power in a social or political sense implies authority and a relation of superior to inferior. Such a relation is possible only on the basis of an order by which the one is empowered to command and the other is obligated to obey. Kelsen describes the concept of power within the state as a structured relationship between those who command and those who obey. This relationship is established through a legal order, which grants authority to certain individuals or institutions and imposes obligations on others. Power, in this sense, is not simply the ability to coerce, but is inherently tied to the legal framework that defines and justifies the roles of those in power and those subject to it. The existence of such a relationship highlights the state's role in organizing and legitimizing social hierarchy through law. Quote 53. The dualism of law and state is a superfluous doubling or duplication of the object of our cognition, a result of our tendency to personify and then to hypostatize our personifications. Kelsen critiques the common view that the state and law are separate entities, describing this as an unnecessary and misleading duplication. He argues that this view stems from the human tendency to personify abstract concepts, and then treat those personifications as real, independent entities. In reality, Kelsen suggests that the state is nothing more than the legal order itself, and there is no need to treat the state as a separate, autonomous entity. This insight challenges the traditional dualistic understanding of the state and law. Quote 54. An action is an act of the state, insofar as it is an execution of the legal order. Kelsen explains that any action attributed to the state must be understood as an execution of the legal order. Whether the action involves creating or enforcing laws, it is only considered an act of the state if it is done in accordance with the legal norms that constitute the state. This emphasizes that the state's authority and activities are entirely rooted in the legal framework, reinforcing the idea that the state is indistinguishable from its legal order. Quote 55. Imputation of a human action to the state is possible only on the basis of a total or partial legal order that we presuppose as valid. Kelsen highlights that attributing an action to the state, whether it is legislative, executive, or judicial, requires a legal framework to give that action meaning and validity. Without a recognized legal order, there would be no basis for considering a particular act as an act of the state. This reinforces the central role of legal norms in defining the state and its actions, suggesting that the existence of the state is entirely dependent on the validity and structure of its legal order. Quote 56. The state acts only through its organs. This often expressed and generally accepted truth means that the legal order can be created and applied only by individuals designated by the order itself. Kelsen emphasizes that the state is an abstract entity and can only act through its organs, which are individuals appointed by the legal system. These individuals are tasked with creating and enforcing the legal order. The state's actions are thus always mediated through legally designated individuals, whether they are lawmakers, judges, or administrators. This reinforces the idea that the state itself has no agency apart from the people who act on its behalf within the framework of the legal order. Quote 57. An organ may be created by appointment, election, or lot. Kelsen explains that the process of creating state organs, or individuals who carry out the functions of the state, can occur through various methods. Individuals may be appointed, elected, or even chosen by random lot to hold a position within the state. Each method of selection reflects the legal system's way of organizing authority, ensuring that the individuals who perform state functions are selected according to a prescribed legal process. This demonstrates the flexibility of legal systems in structuring how state power is distributed and exercised. Quote 58. A function may consist of more than two partial acts. The prototype is the so-called collegiate organ, characterized by the fact that the partial organs function simultaneously in mutual contact. Kelsen describes how some state functions are carried out not by individuals, but by collegiate organs, which are groups of individuals working together. These groups, such as parliaments or courts, perform state functions collectively, with each member contributing to the final decision or action. This structure allows for more complex decision-making processes, where multiple perspectives and partial actions come together to create a unified outcome. Collegiate organs represent a form of governance that emphasizes deliberation and cooperation within the legal framework. Quote 59. The state, as a subject acting through its organs, the state as subject of imputation, the state as juristic person, is the personification of a legal order. Kelsen asserts that the state is not a tangible entity, but rather the personification of a legal order. The state acts through its organs, and its actions are legally attributed to it as if it were a person. This legal fiction allows the state to be treated as a single actor within the legal system, even though it is composed of various individuals and institutions. The concept of the state as a juristic person enables the legal system to assign duties and rights to the state, much like it does with individuals and corporations. Quote 60. Obligations and rights of the state are the obligations and rights of state organs. Kelsen clarifies that when we speak of the state having rights or obligations, we are actually referring to the rights and obligations of the individuals or organs that represent the state. The state, as an abstract entity, does not have its own rights or duties in the way that individuals do. Instead, the actions and responsibilities of the state are carried out by its organs, and the legal system attributes these actions to the state as a whole. This reinforces the idea that the state is a legal construct, made up of the people and institutions that act on its behalf. Quote 61. The state can do no wrong in the sense of national law, but the state can do wrong in the sense of international law. Kelsen distinguishes between the state's legal responsibilities under national law and international law. Under national law, the state is often immune from legal wrongdoing because it represents the highest authority within its own legal system. However, on the international stage, the state can be held accountable for violating international laws or agreements. This distinction highlights the different levels of legal accountability that the state faces, depending on whether it is acting within its own borders or in relation to other states. Quote 62. To deny the possibility of an auto-obligation of the state does not imply an argument for absolutism. Kelsen addresses the notion of auto-obligation, the idea that the state cannot impose legal obligations upon itself. He explains that denying the state's ability to self-regulate through law does not mean endorsing an absolutist form of government where the state operates without legal constraints. Instead, Kelsen argues that individuals who act as state organs can still be subject to the law. This means that even though the state, as an abstract entity, cannot be self-obligated, its representatives are still bound by legal norms. Quote 63. A right of the state exists when the execution of a sanction is dependent upon a lawsuit brought by an individual in his capacity as organ of the state. Kelsen explains that the state has legal rights when it can initiate legal action through its organs, such as officials who act on behalf of the state. For example, a public prosecutor may bring a case to court to enforce a sanction against a criminal. In such cases, the right of the state to act is realized through the legal actions of its representatives. This emphasizes the role of state organs in exercising the state's legal rights, which are always carried out by individuals acting within the scope of their authority. Quote 64. The distinction between public and private law in traditional jurisprudence is made the basis of the systematization of law. Kelsen discusses the long-standing division between public law and private law, which forms the foundation for organizing legal systems. Public law governs the relationship between the state and individuals, while private law regulates relationships between private individuals. This distinction helps to structure legal thinking by differentiating between matters where the state is directly involved and those where individuals interact without direct state involvement. However, Kelsen also suggests that this distinction can be problematic, as the state can also engage in legal relationships traditionally considered private, such as property transactions. Quote 65. The unity of the state territory, and therefore the territorial unity of the state, is a juristic, not a geographical natural unity. Kelsen explains that the unity of a state's territory is based on legal principles, not geographical realities. The state's territory is defined by the area where its legal order is valid, meaning that geographically disconnected areas, such as colonies or enclaves, can still be part of a single state as long as the same legal order governs them. This highlights the legal rather than physical nature of state boundaries, where the coherence of a state is determined by the reach of its legal authority, not by contiguous landmasses. Quote 66. The limitation of the sphere of validity of the coercive order, called state to a definite territory, means that the coercive measures, the sanctions provided by the order, have to be established for this territory only, and have to be executed only within it. Kelsen emphasizes that the coercive power of a state, including the enforcement of its laws, is restricted to its own territory. While a state can enact laws that may influence events outside its borders, its actual power to enforce those laws, especially through coercive measures like sanctions, can only be applied within its territorial limits. This limitation is essential for maintaining the sovereignty of states and ensuring that their legal systems do not interfere with those of other states. The territorial boundary serves as a critical factor in determining where a state's authority begins and ends. Quote 67. The territory of the state is the space within which the state, and that means its organs, are authorized by international law to execute the national legal order. Kelsen clarifies that the territory of a state is defined by the space where its legal order can be enforced, and this enforcement is regulated by international law. The ability of a state to carry out coercive acts within its territory is granted legitimacy by international agreements, which delineate the boundaries of state authority. This demonstrates the interconnectedness of national and international legal systems, where the territorial reach of a state's power is recognized and upheld by international law. Quote 68. The national legal order has exclusive validity for a certain territory, the territory of the state in the narrower sense, and within this territory all individuals are subjected only and exclusively to this national legal order. Kelsen states that within its territorial boundaries, a state's legal order holds exclusive authority, meaning that individuals within the state's territory are subject solely to that state's legal rules. Other national legal systems cannot interfere within these boundaries unless explicitly allowed by international agreements. This exclusivity is key to the concept of sovereignty, ensuring that each state governs its own territory without external influence or conflicting legal orders. Quote 69. The boundaries of a state may be determined by an international treaty. Kelsen points out that the boundaries of a state are often established through international treaties, which formalize territorial changes between states. These treaties grant legal authority over certain areas and are binding agreements that ensure peaceful transfers or demarcations of land. This legal recognition through treaties underscores the role of international law in defining and maintaining the territorial integrity of states. Quote 70. A state remains the same as long as the continuity of the national legal order is maintained. Kelsen explains that a state is considered to maintain its identity as long as its legal order remains continuous, even if there are significant changes in government or territory. The persistence of the legal framework is what defines the ongoing existence of the state, meaning that changes in political leadership or territory do not alter the state's fundamental identity as long as its legal order remains intact. This highlights the centrality of legal continuity in defining the stability and identity of a state. Quote 71. The problem of the temporal sphere of validity of the national legal order is usually presented as the problem of the birth and death of the state. Kelsen presents the question of when a state begins and ends as one tied to the temporal validity of its legal order. A state is born when its legal order first becomes effective, and it dies when that legal order ceases to be valid. This framing shifts the focus from political or social factors, such as revolutions or leadership changes, to the legal system's effectiveness in defining the existence of a state. The legal order's ability to enforce laws and maintain authority over a population and territory is what determines the state's continued existence in this model. Quote 72. A new state in the sense of international law has come into existence if an independent government has established itself by issuing a coercive order for a certain territory and if the government is effective. Kelsen explains that a state is recognized in international law when it meets two criteria. It must have an independent government capable of issuing and enforcing legal orders over a defined territory, and it must demonstrate effectiveness by securing the obedience of the people within that territory. This emphasizes the practical nature of statehood, where a government's ability to maintain control and enforce its laws is central to its recognition as a state by the international community. The existence of a state is thus linked not only to legal principles, but also to the government's actual ability to govern effectively. The exclusive validity of a national legal order extends, according to international law, just as far as this order is, on the whole, efficacious. Kelsen asserts that the territorial boundaries of a state's legal order are defined by its effectiveness. A state's legal system is considered valid within the territory where it is able to enforce its rules and maintain order. This principle of efficacy ensures that state boundaries, both geographic and legal, are determined by the reach of the state's coercive power. If a state loses control over part of its territory, its legal order is no longer valid in that area. This concept underscores the idea that the effectiveness of governance is crucial to the recognition of a state's territorial claims. Quote 74. A state remains the same as long as the continuity of the national legal order is maintained. That is to say, as long as the changes of this order are legitimate. Kelsen explains that the identity of a state is tied to the continuity of its legal order. As long as the legal system remains intact, even through changes in leadership or government structure, the state is considered to be the same entity. This means that a revolution or a change in government does not necessarily create a new state as long as the legal order remains consistent. The legal framework, rather than political upheaval, is the primary factor in determining the persistence of a state. Quote 75. The territory of the state is the space within which the acts of the state, and especially its coercive acts, are allowed to be carried out. Kelsen defines the territory of a state as the area where its legal and coercive powers can be exercised. The state's authority is limited to its territory, where its laws are enforced, and its government functions. This definition emphasizes the link between territory and the power of the state, as a state cannot exert legal or coercive power beyond its recognized borders without violating international law. The legitimacy of a state's actions, particularly those involving force, is thus tied to the geographic area within which it is authorized to operate. Quote 76. The boundaries of the state territory are determined by international law. They are determined according to the principle of effectiveness. Kelsen explains that a state's territorial boundaries are established through international law and are governed by the principle of effectiveness. This means that a state's borders are recognized as valid as long as the state is able to enforce its legal order and maintain control within those boundaries. International law thus provides the framework for determining where one state's authority ends and another's begins, ensuring that territorial disputes are settled based on the effectiveness of governance rather than mere claims. The principle of effectiveness is central to maintaining stable and recognized borders between states. Quote 77. The people of the state are the individuals whose behavior is regulated by the national legal order, that is, the personal sphere of validity of this order. Kelsen explains that the people of the state are defined by the legal system governing their behavior. Just as a state's territory is defined by the geographic boundaries within which its laws apply, the people of the state are those individuals whose actions are regulated by the national legal order. This concept of the people is not merely a demographic or cultural grouping, but a legal classification, indicating who is subject to the authority of the state's legal framework. The unity of the people, much like the unity of the territory, is thus a legal construct, determined by the reach of the national legal order. Quote 78. According to international law, the coercive act provided by the national legal order may be directed only against individuals who are within the territory of the state. Kelsen clarifies that international law limits a state's ability to enforce its laws to individuals who are physically present within its territory. While a state may regulate the behavior of individuals outside its borders, it can only enforce sanctions or coercive acts within its territory. This limitation upholds the principle of territorial sovereignty, ensuring that states cannot apply their coercive powers beyond their own borders unless allowed by international law. It also underscores the territorial nature of legal authority, where a state's coercive reach is confined to the space it governs. Quote 79. Exterritoriality refers to the privilege certain individuals, such as heads of state or diplomatic envoys, enjoy, exempting them from the operation of the ordinary laws of the state. Kelsen explains the concept of exterritoriality, where specific individuals, like diplomats or heads of state, are exempt from the local laws of the country they are in due to international agreements. These individuals are granted immunity from legal actions, such as arrest or prosecution, to ensure that international relations can function smoothly and securely. This exemption from ordinary legal procedures highlights the role of international law in regulating diplomatic relations, creating exceptions to the general rule that all individuals within a state's territory are subject to its laws. Quote 80. Citizenship or nationality is a personal status, the acquisition and loss of which are regulated by national and international law. Kelsen defines citizenship as a legal status determined by both national and international law. The conditions under which someone acquires or loses citizenship vary between legal systems, but are essential in defining the rights and duties of individuals within a state. Citizenship typically grants individuals specific legal rights, such as the right to vote or the obligation to perform military service. This legal status also affects an individual's relationship with other states, especially regarding protection and diplomatic rights. Citizenship is thus a key legal mechanism for defining an individual's place within both the national and international legal orders. Quote 81. Political rights are commonly defined as those rights which give their possessor an influence on the formation of the will of the state. Kelsen discusses political rights as the legal entitlements that allow individuals to participate in the governance of the state. These rights, such as voting or running for office, are typically reserved for citizens and enable them to influence the creation and execution of laws. Political rights are a fundamental aspect of democratic systems, where they ensure that the will of the people is reflected in the government's actions. The distinction between political and civil rights lies in the former's direct connection to the functioning of the state and its legal order. Quote 82. A state whose legal order did not establish a special citizenship would not be able to grant its diplomatic protection to any of its subjects against violation of their interests by other states. Kelsen highlights the importance of citizenship in international relations, noting that without this legal institution, a state would be unable to protect its citizens' interests abroad. Diplomatic protection, such as intervening when a citizen's rights are violated by another state, relies on the clear identification of who belongs to the state. Citizenship serves as the legal link that justifies a state's intervention on behalf of an individual in the international arena. Without this link, individuals would lack the legal backing to claim protection from their home state. Quote 83. The competence of the state is not limited by its nature, and in historical reality, the actual competence of different states is very different. Kelsen argues that there are no inherent, natural limits to the power of a state. The scope of a state's authority is determined by its legal order and can vary widely. Some states may have extensive control over their citizens' lives, while others may restrict their authority to certain areas, like national defense or taxation. The variation in state power reflects different political ideologies, such as liberalism, which advocates for limited government intervention, versus socialism, which supports broader state control. This flexibility in the scope of state authority underscores the role of legal and political systems in shaping the boundaries of state power. Quote 84. The national legal order can regulate human behavior in very different respects and to very different degrees. Kelsen explains that a national legal order has the capacity to regulate various aspects of human behavior, depending on the extent to which the state chooses to intervene in its citizens' lives. This regulation can be comprehensive, covering everything from economic activities to religious practices, or it can be limited to essential functions such as maintaining law and order. The degree to which a state regulates behavior reflects its political and legal philosophy, with more liberal states favoring minimal regulation and more authoritarian states imposing extensive controls. Quote 85. The state is thought of as an aggregate of individuals, a people, living within a certain limited part of the Earth's surface and subject to a certain power. One state, one territory, one people, and one power. Kelsen describes the traditional concept of the state as a unified entity composed of a population living within a defined territory, all subject to a centralized power. This one state, one territory, one people model emphasizes the essential components of statehood: a population, a geographic area, and a governing authority. The unity of these elements is critical to the identity of a state, with its legal order providing the cohesive force that binds these components together. This definition reinforces the classical understanding of the state as a cohesive, sovereign entity operating within fixed territorial boundaries. Quote 86. The power of the state is the validity and efficacy of the national legal order, from the unity of which is derived that of the territory and of the people. Kelsen argues that the true power of the state lies in the effectiveness of its legal system. The legal order's ability to enforce rules and maintain control over its population and territory is what gives the state its authority. The unity of the state's people and territory is a reflection of the legal system's success in governing these elements. This understanding highlights that state power is not just about physical control or political authority, but about the legal order's capacity to function effectively and maintain its validity across the entire territory. Quote 87. Sovereignty can only be the quality of a normative order as an authority that is the source of obligations and rights. Kelsen explains that sovereignty is best understood as a characteristic of the legal order itself, rather than a personal or institutional quality. The legal system, as the source of all rights and obligations within the state, is sovereign because it is the ultimate authority that defines and enforces the rules governing the state's territory and people. This view of sovereignty shifts the focus from individuals or institutions to the legal order, emphasizing that the state's power is rooted in its legal norms rather than in the arbitrary decisions of rulers or political bodies. Quote 88. The differentiation of the executive power into a governmental, political, and an administrative function has, therefore, a political rather than a juristic character. Kelsen points out that the division of executive power into governmental and administrative functions is more of a political distinction than a legal one. While both categories involve the execution of laws, the so-called governmental acts, which are seen as politically significant, are carried out by high-ranking officials, while administrative acts are performed by lower-level bureaucrats. Perspective: both types of acts serve the same function: implementing the law. This distinction reflects the influence of political considerations on the structure of government, even though, legally speaking, the acts are part of the same process of law enforcement. Quote 89. The functions of the state thus prove to be identical with the essential functions of law. It is the difference between creation and application of law that expresses itself in the distinction between the three powers of the state. Kelsen explains that the core functions of the state, legislation, execution, and adjudication, mirror the essential functions of law itself. The distinction between these powers is fundamentally about the creation of laws, legislation, and the application of those laws, execution and adjudication. This reinforces the idea that the structure of the state is deeply intertwined with the nature of the legal order, where the primary role of the state is to both create and enforce the rules that govern society. The division of powers is a reflection of the different stages of the legal process. Quote 90. A law-creating function not taken into account at all by the usual trichotomy is the creation of general norms by way of custom. Kelsen highlights that customary law, which is created through established social practices rather than formal legislation, is often overlooked in the traditional division of state powers. Customary law functions as a legitimate source of legal norms, even though it is not the result of deliberate legislative processes. This recognition broadens the scope of lawmaking within the state, acknowledging that laws can emerge organically from social practices as well as from formal legislative bodies. Customary law operates alongside statutes and regulations as an integral part of the legal system. Quote 91. By legislation is understood not the creation of all general norms, but only the creation of general norms by special organs, namely by the so-called legislative bodies. Kelsen clarifies that legislation refers specifically to the process by which legislative bodies create general norms, while other state organs, such as courts or administrative agencies, may also create legal norms. The term legislation is reserved for those norms produced by bodies that are explicitly tasked with lawmaking. This distinction highlights the special role of legislatures within the legal system, as they are the primary organs responsible for shaping the general legal framework under which the rest of the legal order operates. Quote 92. The legislative power, in principle, creates all the general norms, the laws, but this principle is subject to certain exceptions. Kelsen acknowledges that while legislative bodies are generally responsible for creating laws, there are exceptions where other state organs, such as the executive or judicial branches, may also create general norms. These exceptions allow for flexibility in the legal system, enabling other parts of the state to respond to specific needs or circumstances by creating rules that have the same force as those produced by the legislature. This flexibility ensures that the legal system remains adaptable and responsive to changing conditions. Quote 93. The executive and judicial powers create general norms only as an exception. Their typical task is to create individual norms on the basis of the general norms created by legislation and custom. Kelsen explains that the executive and judicial branches of government usually deal with applying laws to individual cases rather than creating new general norms. Their function is to interpret and enforce the laws that have already been established by the legislative branch or through customary practices. However, there are rare instances where these branches may establish general norms, but such instances are exceptions rather than the rule. This reinforces the idea that the legislative branch holds the primary role in the creation of laws, while the executive and judiciary are focused on implementing those laws in specific cases. Quote 94. The legislative process, that is, the creation of general legal norms, is divided into at least two stages: the creation of general norms, usually called legislation, and the creation of the general norms regulating this process of legislation. Kelsen highlights the complexity of the legislative process, which involves not only the creation of laws, but also the establishment of the rules that govern how laws are made. This second layer of norms, often found in a constitution, regulates the procedures for lawmaking, ensuring that the legislative process follows a structured and lawful approach. This dual aspect of legislation emphasizes that a legal order is built not only on the content of the laws, but also on the principles that guide how those laws are produced. Quote 95. The Constitution of the state, usually characterized as its fundamental law, is the basis of the national legal order. Kelsen emphasizes the critical role of the Constitution as the foundational document of a state's legal system. The Constitution provides the framework within which all other laws are created and applied, making it the most authoritative legal instrument within a national legal order. By setting the fundamental principles of governance, the Constitution defines the structure of the state, the distribution of powers, and the rights of individuals, ensuring the coherence and stability of the entire legal system. Quote 96. A change in the Constitution is made more difficult than the enactment or amendment of ordinary laws. Kelsen explains the concept of a rigid constitution, which is designed to be more difficult to amend than regular laws. This is often done to ensure the stability of the fundamental principles upon which the state is built. By requiring special procedures, such as a supermajority vote or multiple stages of approval, the legal order protects the Constitution from frequent or hasty changes, preserving the foundational structure of the state and preventing instability that could arise from frequent alterations to its core legal framework. Quote 97. Even the most rigid constitution is rigid only with respect to statutory, not customary law. Kelsen points out that even a rigid constitution, which is difficult to amend through formal legislative processes, can still be influenced by customary law. Customary practices, which evolve over time through repeated behavior, can effectively modify the Constitution without formal amendments. This highlights the flexibility of legal systems, where established customs can take on the force of law and shape the interpretation and application of the Constitution, even when formal amendments are restricted. Quote 98. The preamble usually does not stipulate any definite norms for human behavior and thus lacks legally relevant contents. It has an ideological rather than a juristic character. Kelsen explains that the preamble of a constitution, while often solemn and filled with political or moral ideals, does not typically create binding legal obligations. Instead, the preamble serves an ideological function, setting the tone and expressing the values that the Constitution aims to promote. Although it may enhance the dignity and symbolic importance of the Constitution, the preamble itself is not enforceable law and does not impose specific legal duties or rights on individuals. Quote 99. There is a remarkable technical difference between provisions of the Constitution forbidding and provisions prescribing a certain content for future laws. Kelsen distinguishes between constitutional provisions that prohibit certain actions, such as restricting freedom of speech, and those that require specific content in future laws, such as ensuring equal treatment. While prohibitive provisions tend to have immediate legal effects if violated, prescriptive provisions often lack enforcement mechanisms if lawmakers fail to act. This highlights a key difference in how different types of constitutional norms function within the legal system, with prohibitions being more immediately enforceable and prescriptive mandates being harder to compel. Quote 100. Constitutional prohibitions have the desired effect only if they are directed also to the legislative organ, and if the Constitution is a rigid, not a flexible, one. Kelsen notes that constitutional prohibitions, such as protections of individual rights, are only effective if they are applied to the legislature and enforced through a rigid constitutional structure. In flexible constitutions, where changes can be made easily, prohibitions can be overridden by simple legislative acts, diminishing their protective power. The rigidity of the Constitution is essential to ensuring that certain fundamental rights or prohibitions remain intact, even in the face of shifting political or legislative agendas. Quote 101. The possibility of a law issued by the legislative organ being annulled by another organ constitutes a remarkable restriction of the former's power. Kelsen discusses judicial review, where courts have the power to annul laws that are deemed unconstitutional. This ability to invalidate laws imposes a significant check on the power of the legislative branch, ensuring that laws conform to the Constitution. Judicial review introduces a form of negative legislation, where courts can override legislative actions, thus creating a balance of power between the legislative and judicial branches. This safeguard helps to maintain the integrity of the constitutional framework by preventing the legislature from overstepping its bounds. Quote 102. The concept of separation of powers designates a principle of political organization. It presupposes that the three so-called powers can be determined as three distinct coordinated functions of the state. Kelsen explains that the principle of the separation of powers assumes that the legislative, executive, and judicial branches of government can be clearly distinguished as three independent and coordinated functions. This concept is central to political organization in many democratic systems, particularly in the United States, where each branch is meant to operate separately to prevent the concentration of power. However, Kelsen critiques this assumption, pointing out that in practice, the separation is not as clear-cut, as many governmental acts involve both the creation and application of law simultaneously. Quote 103. There are not three but two basic functions of the state: creation and application, execution of law. And these functions are not coordinated but sub- and supraordinated. Kelsen argues that, in reality, the state's functions can be reduced to two: the creation of law and its application. These functions are not equal but operate in a hierarchical relationship, where the creation of law is superior to its application. The traditional division into three branches, legislative, executive, and judicial, oversimplifies the complex interplay between these functions. For Kelsen, the boundaries between creating and applying laws are often blurred, as both tasks can occur within the same act. Quote 104. Most acts of state being at the same time law-creating and law-applying acts. Kelsen emphasizes that many state actions serve both to create and apply laws, contradicting the idea of a strict separation between the branches of government. For instance, judicial decisions often establish legal precedents, creating law, while simultaneously resolving specific cases, applying law. This dual function of state acts makes it difficult to maintain a rigid division of powers. The overlap between creating and applying laws demonstrates the interconnected nature of state functions, which challenges the practicality of a pure separation of powers. Quote 105. By legislation as a function, we can hardly understand anything other than the creation of general legal norms. Kelsen clarifies that legislation, in its purest form, refers to the creation of general legal norms that apply to all citizens. The legislative function, therefore, is distinct from other state functions, such as executing or adjudicating laws. However, he also notes that in practice, other organs of the state, including courts and administrative bodies, often contribute to the creation of general norms, either through interpretation or regulations. This reinforces the idea that legislation is not exclusively the domain of a single legislative body. Quote 106. The legislative competence vested in the head of the executive department is sometimes very extensive. Kelsen acknowledges that many constitutions grant the executive branch, particularly the head of state, substantial legislative powers, especially in times of crisis, such as war or economic instability. This power allows the executive to create laws without prior authorization from the legislature. However, such power is only temporary and limited, meant to address urgent situations when the legislative process may be too slow to respond effectively. This exception to the principle of separation demonstrates the flexibility of constitutional systems in allowing the executive to assume legislative functions when necessary. Quote 107. Courts fulfill a legislative function when authorized to annul unconstitutional laws. Kelsen points out that courts, especially constitutional courts, play a legislative role when they have the power to annul laws that conflict with the Constitution. This judicial review effectively allows courts to shape the legal landscape by determining which laws are valid, thereby participating in the creation of legal norms. While traditionally seen as a law-applying function, This role grants the judiciary considerable influence over the legislative process, further blurring the distinction between the branches of government. Quote 108, thus one can hardly speak of any separation of legislation from the other functions of the state, in the sense that the so-called legislative organ would alone be competent to exercise this function. Kelsen critiques the notion that only the legislative branch has the authority to create laws. In reality, the legislative function is distributed among various state organs, including the executive and judiciary, which also contribute to lawmaking. The traditional view that the legislature has a monopoly on creating laws is, according to Kelsen, an oversimplification. Instead, lawmaking is a shared responsibility, with different branches contributing to the creation of general norms through their specific roles. Quote 109. A strict separation of the two powers is impossible, since the two types of activity usually designated by these terms are not essentially distinct functions. Kelsen argues that the judicial and executive functions are not as distinct as they are often portrayed. Both functions involve the application and enforcement of laws, and there is significant overlap between the two. For instance, administrative bodies often carry out quasi-judicial functions, such as resolving disputes or imposing penalties, while courts sometimes engage in administrative tasks. This practical overlap makes it difficult to maintain a strict separation between the judicial and executive branches. Quote 110. The principle of the separation of powers would be satisfied if the administrative organs were limited to the specific administrative acts and if the specific judicial function were reserved for the courts. Kelsen explains that the ideal form of separation of powers would involve administrative organs focusing solely on administrative tasks, such as issuing orders or licenses, while courts would handle all judicial matters, including the enforcement of laws. However, this ideal is rarely realized in practice. Administrative bodies often take on judicial roles, such as adjudicating disputes or imposing sanctions, particularly in areas like taxation and regulation. This blending of functions undermines the strict separation of powers, but reflects the needs of governance. Quote 111. Democracy means that the will which is represented in the legal order of the state is identical with the wills of the subjects. Kelsen describes democracy as a system where the legal order reflects the collective will of the people. In a true democracy, the laws and regulations imposed by the state align with the wishes of the individuals governed by them. This idea of political freedom is central to Kelsen's definition of democracy, emphasizing that individuals are politically free when they have a say in the creation of the rules that govern their behavior. In contrast, autocracy excludes the subjects from participating in the creation of the legal order, leading to a disconnect between the individual's will and the legal system. Quote 112. Politically free is he who is subject to a legal order, in the creation of which he participates. Kelsen ties political freedom to participation in the legislative process. Individuals are considered free when they have the ability to influence the laws they are subject to, whether through direct involvement or representation. This idea contrasts with systems where individuals are governed by laws created without their input. In democratic societies, political freedom is safeguarded by ensuring that all citizens have the opportunity to participate in lawmaking, either directly or indirectly. Quote 113. The ideal of self-determination requires that the social order shall be created by the unanimous decision of all its subjects. Kelsen acknowledges the theoretical ideal of democracy, a society where every individual consents to the social order, and all decisions are made unanimously. However, he also recognizes that this ideal is impossible to achieve in practice. The need for unanimity would paralyze decision-making and prevent any meaningful governance, as even a single dissenting individual could block any action. Therefore, the ideal of self-determination must be modified to make democratic governance practical, leading to the adoption of majority rule. Quote 114. The greatest possible degree of individual liberty is guaranteed by the principle that a change of the social order requires the consent of the simple majority. Kelsen explains that the principle of majority rule is the most practical, balancing individual liberty with the need for social order. In a democracy, decisions about changing the legal order are made by a simple majority, ensuring that the will of the majority of citizens is respected, while minimizing the likelihood of widespread dissatisfaction. This approach allows for efficient decision-making while still adhering to the democratic principle of reflecting the collective will of the people, ensuring that the legal order is aligned with the preferences of most citizens. Quote 115. The principle of majority in a democracy is observed only if all citizens are permitted to participate in the creation of the legal order. Kelsen emphasizes that true democracy is not just about majority rule, but also about inclusive participation. For a state to be genuinely democratic, all citizens must have the right to participate in the creation of laws, regardless of whether their views align with the majority. The exclusion of any group from the legislative process undermines the democratic principle. Therefore, while the majority may determine the content of laws, the process must be open to all citizens to ensure fairness and legitimacy in the democratic system. Quote 116. Free discussion between majority and minority is essential to democracy because this is the way to create an atmosphere favorable to a compromise between majority and minority. Kelsen underscores the importance of open dialogue in a democracy. The constant exchange of ideas between the majority and minority creates opportunities for compromise, which is a key feature of democratic governance. Compromise ensures that the interests of both the majority and the minority are considered when laws are created. This process of negotiation and adjustment leads to a more inclusive legal order that reflects a broader range of perspectives, making voluntary compliance with the law more likely and fostering political stability. Quote 117. The legal independence of Parliament from the electorate can be justified only by the opinion that the legislative power is better organized when the democratic principle is not carried to extremes. Kelsen critiques the independence of elected representatives from their voters, noting that this can only be justified by the belief that the legislative process functions better when representatives are not bound to follow the direct will of the electorate. In modern democracies, representatives often have a degree of autonomy, which allows them to make decisions based on their judgment rather than strictly adhering to the wishes of their constituents. This independence is seen as a way to avoid the pitfalls of direct democracy, where frequent changes in public opinion could lead to instability. Quote 118. The formula that the Member of Parliament is not the representative of his electors, but of the whole people, is a political fiction. Kelsen argues that the idea that elected representatives act on behalf of the entire population, rather than just their voters, is more of a political theory than a reality. In practice, representatives are often influenced by the interests of the specific constituencies that elect them, rather than by the will of the broader population. This critique challenges the notion that parliamentary democracy is a perfect reflection of the people's will, suggesting that the system is more complex and influenced by various factors beyond direct representation. Quote 119. Democracy requires that the right of suffrage should be not only as nearly universal, but also as nearly equal as possible. Kelsen emphasizes that for a democracy to function properly, the right to vote must be both universal and equal. Universal suffrage means that all citizens, regardless of gender, profession, or status, should have the right to vote, while equality in suffrage ensures that each vote carries the same weight. Kelsen critiques any system that allows for unequal voting power, such as plural voting, where certain individuals have more votes than others based on criteria like literacy or tax contributions. The core democratic principle is that all citizens should have an equal say in elections, reinforcing both political fairness and the legitimacy of the elected government. Quote 120. The political party is an essential vehicle for the formation of the public will. Kelsen explains that political parties play a crucial role in shaping public opinion and influencing the direction of government policy in a democracy. Individuals in a parliamentary democracy typically have little direct influence on legislative and executive decisions unless they align themselves with others who share their views through political parties. These parties organize individuals into cohesive groups that can exert collective influence on the electoral process and on the formation of government. Without political parties, the democratic system would struggle to function, as the isolated individual would find it difficult to impact the governance process effectively. Quote 121. The system of proportional representation is the greatest possible approximation to the ideal of self-determination within a representative democracy. Kelsen advocates for proportional representation as the electoral system that most closely aligns with the democratic ideal of self-determination. In proportional representation, political groups are represented in legislative bodies in proportion to their share of the vote, ensuring that even minority groups have a voice. This system contrasts with majority voting systems, which often result in the dominance of the majority group and underrepresentation of minority groups. Proportional representation creates a more accurate reflection of the political landscape, allowing the diverse views of the electorate to be more fairly represented. Quote 122. It is essential for a democracy only that the formation of new parties should not be excluded, and that no party should be given a privileged position or a monopoly. Kelsen stresses that a key feature of democracy is the freedom to form new political parties and the absence of favoritism towards any single party. A democratic system must allow for the creation of new parties so that citizens can express their diverse political opinions and pursue change. Granting one party special privileges or a monopoly undermines the fundamental principles of democracy by stifling competition and suppressing alternative viewpoints. In a healthy democracy, all parties should have equal opportunities to compete for power, ensuring that the government remains accountable to the people. Quote 123. Democracy at the stage of legislation means that, in principle, all the general norms are created by a parliament elected by the people. Kelsen explains that democracy in the legislative process involves the creation of laws by a parliament that is elected by the people. This ensures that the laws governing society reflect the will of the electorate. In a democratic system, the legislative body is directly accountable to the people, as its members are chosen by citizens through elections. This principle is foundational to democratic governance, as it guarantees that the laws are created by representatives who are tasked with acting in the best interests of their constituents. Quote 124. The system of proportional representation must be distinguished from so-called minority representation, an electoral system whose purpose it is to guarantee adequate representation only to one, namely, the comparatively strongest minority group. Kelsen draws a distinction between proportional representation, which seeks to fairly represent all political groups according to their numerical strength, and minority representation, which focuses on ensuring representation for the largest minority group. Proportional representation allows for a more comprehensive reflection of the electorate by representing all groups based on their proportion of the vote. Minority representation, by contrast, may overrepresent certain groups while underrepresenting others, distorting the political balance. Proportional representation, therefore, offers a more democratic and equitable method for electing representatives. Quote 125. One of the advantages of the system of proportional representation is that no competition of candidates of different political parties is necessary. Kelsen points out that proportional representation eliminates the need for direct competition between candidates from different political parties in many cases. Under this system, each political group elects its delegates based on its share of the vote, without candidates needing to compete directly against one another for the same seats. This approach can reduce the adversarial nature of elections, fostering a more cooperative political environment. By allowing each group to secure representation based on its actual support, proportional representation provides a more accurate and peaceful method of reflecting the public's political preferences. Quote 126. The ideal of democracy can be realized to a higher degree when the elected organ is collegiate than when it consists of a single individual. Kelsen argues that democracy functions more effectively when decision-making bodies are composed of multiple individuals, collegiate bodies, rather than a single elected official. Collegiate bodies, such as parliaments or councils, allow for greater representation of diverse viewpoints, as they are more likely to include members from different political groups. This enhances the democratic process by ensuring that minority perspectives are heard and considered in decision-making. In contrast, a single individual's decisions may reflect only a narrow set of interests, potentially weakening the democratic principle of inclusiveness. Quote 127. A local body where the parliamentary minority is in the majority would be inclined to disregard or to apply less conscientiously laws enacted by Parliament against the votes of the minority. Kelsen explains that when local governing bodies are controlled by a political minority, they may be less likely to enforce national laws that were passed by the majority in Parliament. This situation can create a conflict between local and national governments, undermining the rule of law and the unity of the legal order. In such cases, the minority-controlled local body may resist implementing laws that go against its political beliefs, potentially weakening the democratic process by failing to adhere to the legal decisions made by the elected majority. Quote 128. The conception of a centralized legal order implies that all its norms are valid throughout the whole territory over which it extends. This means that all its norms have the same territorial sphere of validity. Kelsen explains that in a centralized legal system, the legal norms apply uniformly across the entire territory of the state. This means that the laws are consistent and applicable in every region of the country without variation. Centralization ensures that there is a single legal framework governing all parts of the territory, making legal enforcement and interpretation uniform across the state. This contrasts with decentralized systems, where different regions may have their own legal norms that apply only locally, leading to a more complex legal landscape with varying laws across the territory. Quote 129. A decentralized legal hand consists of norms that have different territorial spheres of validity. Kelsen contrasts centralization with decentralization by noting that in a decentralized system, legal norms can differ depending on the region. Each part of the state may have its own set of rules that only apply within that specific area, allowing for a more localized approach to lawmaking and governance. Decentralization allows regions to create laws that are tailored to their particular needs, reflecting local preferences and conditions. This creates a more flexible legal structure, but also introduces the potential for inconsistency across different regions within the same state. Quote 130. The larger the territory of the state, and the more varied the social conditions, the more imperative will decentralization by territorial division be. Kelsen argues that decentralization becomes more necessary in larger states with diverse populations and varied social conditions. In such contexts, a single set of legal norms may not adequately address the differing needs and circumstances of various regions. Decentralization allows different areas to create laws that reflect their unique cultural, economic, or social conditions, thus providing a more responsive and effective system of governance for large and heterogeneous states. Quote 131. The central community as well as the local communities are members of the total community. Kelsen emphasizes that both the central legal order and local legal orders coexist within the same state. While local communities may have their own norms and regulations, they are still part of the larger national legal framework. This relationship ensures that local laws do not operate independently of the state, but within the broader structure of the national legal system. Central and local communities thus work together to form the complete legal order of the state. Quote 132. Democracy demands the utmost conformity between the general will, as expressed in the legal order, and the will of the individuals subject to the order. Kelsen highlights that in a democratic system, the laws should reflect the will of the people who are governed by them. For democracy to function effectively, there must be a close alignment between the laws that are created and the preferences of the citizens. This principle ensures that the legal order is legitimate in the eyes of the people and that individuals feel a sense of ownership and responsibility toward the laws that govern them. The closer the laws match the will of the people, the more democratic the system becomes. Decentralization. Quote 133. Decentralization allows a closer approach to the idea of democracy than centralization. Kelsen explains that decentralization can bring the legal order closer to the ideal of democracy by allowing local populations to have more control over the laws that apply to them. In a decentralized system, local communities can create laws that better reflect their specific needs and values, leading to a more direct form of self-governance. This enhances the democratic principle of self-determination, as individuals in different regions can shape the legal order that directly affects their lives. Quote 134. Static decentralization entails dynamic decentralization, and dynamic decentralization involves a transfer of power from the autocrat to his representative, and hence a weakening of the autocratic principle. Kelsen observes that when decentralization occurs in an autocratic system, it often leads to a transfer of power from the central authority to regional representatives. This process weakens the autocratic system, as it dilutes the concentration of power in the hands of a single ruler. As local authorities gain more control over regional matters, the central authority becomes less dominant, making the system more decentralized and, by extension, less autocratic. Quote 135. Perfect decentralization occurs when the creation of local norms is final and independent. Kelsen describes perfect decentralization as a system where local authorities have complete control over the creation of laws within their jurisdiction, without interference from the central government. In such a system, local norms are final and cannot be overridden or replaced by central laws. This creates a highly autonomous system of local governance, where regions have full legal independence in specific matters, though they still remain part of the broader national legal framework. Quote 136. Local autonomy represents normally a type of a comparatively perfect decentralization. Kelsen explains that local autonomy, particularly in the form of municipal self-government, is an example of effective decentralization. In this system, local authorities, such as elected municipal councils, have the power to govern local matters and create laws that apply within their jurisdiction. This form of governance allows local populations to have a direct say in how they are governed, reinforcing democratic principles while maintaining decentralization. The scope of authority may be limited to specific local issues, but it provides a model of governance where the local government operates independently of the central administration. Quote 137. Decentralization may be extended to legislation, the creation of general norms. This is normally connected with a comparatively larger territorial sphere of validity of the norms concerned. Kelsen explains that decentralization can go beyond administrative functions to include the legislative creation of general laws. When legislation is decentralized, the norms created by regional authorities apply to broader territories within the state. This type of decentralization usually occurs in systems where local regions, such as autonomous provinces, have the power to make laws that reflect the specific needs and preferences of their populations. By granting legislative powers to local authorities, decentralization enhances regional autonomy and allows for a more tailored approach to governance, in contrast to centralized systems where laws are uniformly applied across the entire state. Quote 138. The federal state is characterized by the fact that the component states possess a certain measure of constitutional autonomy. Kelsen describes the defining feature of a federal state as the constitutional autonomy of its component states. In a federal system, each region or state within the federation has the power to establish its own constitution and legislate on matters within its jurisdiction, subject to certain limitations imposed by the federal constitution. This autonomy differentiates a federal state from a unitary state, where the central government retains control over most legislative matters. The component states in a federal system have the ability to shape their legal frameworks independently, allowing for a higher degree of decentralization. Quote 139. The centralization in the federal state is limited by the fact that the central law-creating organ is composed in the following manner, especially typical of the federal state. It consists of two houses. Kelsen points out that in federal states, centralization is constrained by the structure of the central legislative body, which typically consists of two houses, a House of Representatives and a Senate. This bicameral system reflects the federal principle by ensuring that the interests of both the general population and the component states are represented in the law-making process. The Senate, in particular, represents the component states, often granting them equal representation regardless of size or population. This arrangement limits the centralization of power by ensuring that the component states have a direct influence on national legislation, preserving the balance between central and local authority. Quote 140. The component states of a federal state normally are not subjects of international law. Only the federal state has international rights and duties. Kelsen explains that in a federal state, the component states do not have independent standing under international law. Instead, it is the federal government that represents the entire nation in international affairs, holding rights and responsibilities under international law. This means that, while component states may have a degree of domestic autonomy, they are not recognized as separate entities in the international arena. The federal government acts as the sole representative of the state in matters such as diplomacy, treaties, and international disputes, reinforcing the central authority in external relations. Quote 141. It implies a certain centralization if the central norms have no need for this mediation of local norms to obligate and authorize individuals. Kelsen discusses the relationship between central and local laws in federal systems. Centralization occurs when federal laws directly obligate and authorize individuals without the need for local laws to mediate these obligations. In more decentralized systems, the central government relies on local authorities to implement federal laws, requiring local norms to translate federal mandates into actionable rules for individuals. Direct federal authority over individuals signifies a higher degree of centralization, as the central government can impose laws uniformly across the entire state without relying on local governments for implementation. Quote 142. In the International Confederacy, there is no citizenship of the Confederation. The individuals are citizens of the member states only. Kelsen explains that in an international confederacy, individuals are citizens of their respective member states, not of the confederacy itself. This contrasts with federal states, where individuals hold dual citizenship, both within their component state and the federal union. In a confederacy, the legal relationship between individuals and the central authority is indirect, mediated through their member state. The confederacy is thus a looser organization of sovereign states, where individuals' legal obligations and rights are primarily governed by their national laws rather than by a central authority. Quote 143. Normally, a federal state comes into existence through an international treaty concluded by independent states. Kelsen notes that federal states are often formed when independent states come together through an international treaty, agreeing to unite under a shared federal constitution. This historical process reflects the origins of many modern federations, where formerly sovereign entities voluntarily cede certain powers to a central government while retaining autonomy over local matters. The federal constitution serves as the framework that governs the relationship between the central government and the component states, ensuring that the rights and duties of both levels of government are clearly defined. Quote 144. The Confederacy of States usually has no police, army, navy, or air force of its own. The member states remain in unrestricted possession of all their instruments of power. Kelsen highlights a key difference between a confederacy and a federal state. In a confederacy, the member states retain full control over their military and police forces. The central authority of a confederacy does not possess its own enforcement mechanisms, relying instead on the member states to contribute resources in times of need. This arrangement underscores the decentralized nature of confederacies, where the central government lacks the coercive power typically associated with sovereign states. It maintains significant independence in matters of defense and law enforcement. Quote 145. International law is law in this sense if the coercive act of a state, the forcible interference of a state, in the sphere of interests of another, is permitted only as a reaction against a delict, and the employment of force to any other end is forbidden. Kelsen argues that for international law to be considered true law, it must function like national law, where coercive acts are only permitted as sanctions in response to delicts, violations of legal norms. In this framework, states can only use force legally as a reaction to illegal actions by other states. If force is employed for other purposes, it would constitute a delict. This structure of delict and sanction mirrors the principles of national law, thus enabling international law to be seen as a legitimate legal system, with clear rules governing the use of force between states. Quote 146. It is a commonly accepted view that there exists in international law such a thing as a delict, that is, conduct of a state which is considered illegal, contrary to international law, and, therefore, a violation of international law. Kelsen affirms that international law, like national law, recognizes the concept of a delict, where certain actions by states are deemed illegal. When a state violates the norms established by international law, such as by invading another state's territory or breaching a treaty, it commits a delict. This concept of illegal state behavior is essential to maintaining order in the international community, as it provides a basis for identifying violations of international law and for determining when a coercive response, or sanction, may be justified. Quote 147. The specific sanction of a legal order can only be a coercive act provided by the legal order for the case where an obligation is violated. Kelsen highlights that sanctions in a legal order must involve a coercive response to a violation of legal norms. In international law, this means that when a state commits a delict, such as violating a treaty or engaging in illegal aggression, other states or international bodies are permitted to respond with force or other coercive measures. This idea underscores the importance of sanctions in maintaining the integrity of legal orders, as without the threat or use of sanctions, the rules of international law would lack enforceability. Quote 148. It is generally admitted that intervention is, as a rule, forbidden by international law. Kelsen explains that the principle of non-intervention is a fundamental aspect of international law. States are generally prohibited from interfering in the internal or external affairs of other states, especially through the use of force. This norm protects the sovereignty and independence of states, ensuring that each state has the right to govern its own affairs without outside interference. However, there are exceptions to this rule, where intervention may be justified if it is a response to a violation of international law, thus linking intervention to the concept of sanctions against delicts. Quote 149. War is an unlimited interference in the affairs of another state, implying the use of force. It is an intervention which possibly leads to the complete destruction of another state's external and internal independence. Kelsen defines war as the most extreme form of intervention, where one state uses force against another with the potential to entirely destroy the other's sovereignty. This characterization of war highlights its devastating impact on the targeted state, as it can lead to the loss of both external independence, control over foreign relations, and internal independence, control over domestic affairs. By framing war as a severe violation of another state's interests, Kelsen underscores the need for international law to regulate when and how war can be justifiably waged. Quote 150. From what has been said so far, it may be inferred that general international law, characterized by the legal technique of self-help, can be interpreted in the same manner as a primitive legal order. Kelsen likens international law to primitive legal systems, where the enforcement of rights often depends on self-help, meaning states must defend without the assistance of a centralized authority. In primitive societies, individuals took justice into their own hands through acts like revenge, just as states today may resort to force, war, or reprisals to address violations of international law. This comparison emphasizes the decentralized and rudimentary nature of international law, where each state acts as both judge and enforcer in the absence of a supranational authority with the power to impose sanctions uniformly. Quote 151. The idea of just war forms the basis of a number of highly important documents in positive international law, namely the Peace Treaty of Versailles, the Covenant of the League of Nations, and the Kellogg Pact. Kelsen notes that the concept of just war underpins major international agreements such as the Treaty of Versailles, the Covenant of the League of Nations, and the Kellogg Pact. These agreements embody the principle that war is only permissible as a response to a wrongful act, reinforcing the notion that international law seeks to limit the use of force to situations where it serves as a justified sanction. The idea of just war ensures that war is seen as a reaction to illegal conduct, rather than a legitimate tool for pursuing national interests without restraint. Quote 152. The weightiest objection to the theory of just war, however, is the one which claims that according to general international law, war cannot be interpreted either as a sanction or as a delict. Kelsen identifies the most significant critique of the just war theory, which argues that war, according to international law, cannot consistently be classified as either a sanction or a delict. This critique highlights the difficulty in determining whether a war is justified or illegal, especially in the absence of an international tribunal to adjudicate such disputes. Without a clear, authoritative decision-making body, the classification of war as a lawful sanction or an unlawful delict remains ambiguous, complicating the application of international law to the conduct of states during conflict. Quote 153. All law is regulation of human behavior. The only social reality to which legal norms can refer are the relations between human beings. Kelsen highlights that law, whether national or international, exists to regulate human behavior. Even though international law is often seen as governing the relations between states, it must still operate through individuals, since states act through their human representatives. Therefore, even though the language of international law often speaks of states, it is the actions of individuals acting as organs of those states that are actually governed by legal norms. This underscores the idea that all legal systems, at their core, deal with regulating human behavior. Quote 154. The norms of international law usually determine only the material element and are, in this sense, incomplete. They await supplementation by the norms of national law. Kelsen discusses the idea that many norms of international law are incomplete because they only outline the general duties or obligations of states without specifying the individuals responsible for carrying them out. National legal systems fill this gap by determining which individuals or authorities within a state must perform the obligations imposed by international law. This division of responsibility between international and national law illustrates how the two systems are interdependent and work together to regulate behavior effectively. Quote 155. The sanction provided against piracy is not directed against a state, and in particular, not against the state of which the pirate is a citizen. The sanction is directed against the pirate, as against an individual who has violated his obligation under international law. Kelsen uses the example of piracy to illustrate how international law can impose sanctions directly on individuals rather than on states. Pirates, who operate outside the laws of any one state, are subject to international law, and any state has the right to capture and punish them. This reflects the principle of individual responsibility under international law, where certain actions, such as piracy, are treated as international crimes, and the individuals responsible can be punished regardless of their nationality or the actions of their home state. Quote 156. It is, however, only in exceptional cases that international law directs or authorizes individuals. Kelsen acknowledges that while international law can directly impose obligations or confer rights on individuals, these cases are rare. Most of the time, international law operates through states, which are responsible for implementing international legal norms and ensuring compliance by their citizens. The direct regulation of individuals by international law is an exception rather than the rule, typically reserved for situations involving crimes like piracy. war crimes, or violations of human rights. Quote 157. International law regulates the mutual behavior of states, but this does not mean that international law imposes duties and confers rights only upon states, not upon individuals. Kelsen explains that although international law primarily governs the behavior and relations between states, it also indirectly imposes obligations and grants rights to individuals. The misconception is that international law applies solely to states, but Kelsen argues that, through the actions of state organs, individuals are also bound by international law. For example, treaties signed by states often result in national laws that directly regulate individual behavior. Therefore, international law, while operating on a state level, ultimately affects individuals within those states. Quote 158. International law obligates and authorizes individuals indirectly through the medium of the national legal order. Kelsen clarifies that international law often operates indirectly by influencing national legal systems, which, in turn, impose obligations on individuals. When states enter into international agreements, they often pass domestic legislation to enforce those agreements. In this way, international law affects individuals, but it does so through the framework of national laws that bring international obligations into the domestic sphere. This reflects the interconnectedness of national and international legal systems, where international norms filter down to individuals through state mechanisms. Quote 159. There are, however, important norms of international law which impose obligations or confer rights directly upon individuals. Kelsen acknowledges that while most international law operates indirectly through states, there are significant exceptions where international law directly regulates individual behavior. For example, individuals can be directly subject to international law in cases of piracy, war crimes, or human rights violations. In such instances, international law bypasses national systems and holds individuals directly accountable for their actions, which demonstrates the capacity of international law to operate independently of state mediation. Quote 160. Individuals can have international rights only if there is an international court before which they can appear as plaintiffs. Kelsen asserts that for individuals to possess rights under international law, there must be a judicial mechanism such as an international court where they can assert those rights. Without such a court, individuals would have no means of enforcing their international rights or seeking redress for violations. This highlights the necessity of institutions like the International Court of Justice or other tribunals in ensuring that individuals have a platform to claim and defend their rights on the international stage. Quote 161. There is no subject matter which can be regulated only by national law, and not by international law. Kelsen challenges the idea that there are matters exclusive to national law. He argues that any issue that can be regulated by national law could also potentially be addressed by international law. This reflects the broad scope of international law, which can encompass issues traditionally seen as domestic, such as human rights, environmental protection, or trade. Kelsen's view reinforces the idea that international law is not limited to purely interstate matters, but can overlap with the subjects regulated by national legal systems, making it a powerful and comprehensive legal framework. Quote 162. The basic norms of the national legal orders are determined by a norm of international law. Kelsen asserts that the foundational norms of national legal systems are ultimately derived from international law. This means that the legitimacy and validity of national legal orders are grounded in principles recognized by the international community. According to this view, international law plays a fundamental role in shaping and supporting the structure of national legal systems, creating a relationship where international law serves as the higher-order legal framework from which national laws gain their authority. This supports a monistic view of law, where international and national legal systems are seen as part of a single unified legal order. Quote 163. Victorious revolution and successful coup d'etat are, according to international law, law-creating facts. Kelsen explains that when a government is overthrown by a revolution or coup, and the new regime's successful control, international law recognizes the new government as legitimate. This principle of effectiveness means that if the new regime can maintain order and enforce laws, it is accepted as the legal authority, regardless of how it came to power. This recognition of new governments, even when they emerge through unconstitutional means, highlights the practical approach of international law in dealing with changes in state authority, where the focus is on the ability to govern effectively rather than the legality of the transition. Quote 164. The validity of these norms is dependent upon the norm pacta sunt servanda, which itself is a norm belonging to the first stage of general international law. Kelsen refers to the principle pacta sunt servanda, agreements must be kept, as a foundational norm of international law. This principle underpins the validity of treaties and international agreements, ensuring that states are bound by the commitments they make. It is one of the core norms that sustain the international legal order, establishing trust and predictability in international relations. By upholding this principle, it ensures that states honor their obligations, making treaties and agreements enforceable across the global community. Quote 165. International law obligates a state to give its norms certain contents, in the sense that if the state enacts norms with other contents, then the state is liable to an international sanction. Kelsen explains that international law often imposes requirements on states regarding the content of their national laws. If a state enacts laws that conflict with its international obligations, it may face sanctions or penalties from the international community. This illustrates the influence of international law on national legal systems, where states are not entirely free to legislate as they wish, if doing so would violate international agreements or customary international law. The possibility of international sanctions acts as a deterrent, encouraging states to align their national laws with their international commitments. Quote 166. The unity of national and international law is an epistemological postulate. Kelsen argues that the unity of national and international law is a fundamental assumption within legal theory. For a legal scholar who accepts both systems as valid, they must be understood as parts of a single, coherent legal system. This unity can be conceptualized in different ways, either by viewing international law as superior to national law or by considering both as deriving their authority from a higher, overarching legal order. Kelsen's monistic perspective emphasizes that international and national law are not separate, independent systems, but interconnected elements of a broader legal framework. Quote 167. The principle ex injuria jus non oritur may belong to a given positive legal order, but does not necessarily do so. Kelsen discusses the principle ex injuria jus non oritur, law does not arise from injustice, explaining that while this principle may be part of a legal system, it is not an absolute rule. In some cases, legal norms can arise even from actions considered unlawful under a previous regime, such as when a revolution or coup leads to the creation of a new legal order. This demonstrates the flexibility of legal systems in adapting to new political realities, where the law recognizes changes in power and authority, even when they result from actions that were initially illegal. Quote 168. The possibility of unconstitutional laws does not, therefore, affect the unity of the national legal order, so the possibility of a national law violating international law does not affect the unity of the legal system comprising both. Kelsen argues that the existence of laws that violate either a constitution or international law does not undermine the overall unity of the legal system. Just as a law that violates a constitution remains valid until it is annulled, a national law that conflicts with international law remains part of the legal system until it is addressed. This demonstrates that contradictions within the legal system do not destroy its coherence. Rather, they are dealt with through mechanisms like judicial review or sanctions. The legal system retains its unity, even when individual laws may conflict with higher norms. Quote 169. The identity of the state as subject of international law and as subject of national law means that, finally, the international legal order obligating and authorizing the state and the national legal order determining the individuals who, as organs of the state, execute its international duties and exercise its international rights, form one and the same universal legal order. Kelsen argues that the state functions simultaneously within both international and national legal frameworks, yet these systems are not distinct but part of a single legal order. The international legal order imposes obligations and grants rights to the state, while the national legal system governs the individuals who implement these obligations. Both systems are interconnected, and the actions of the state on the international stage are executed through the national legal apparatus. This integration challenges the idea that international and national laws are separate, suggesting instead that they form a cohesive universal legal system where the state serves as a bridge between them. Quote 170. International law needs transformation into national law only when the necessity thereof is stated by the Constitution of the state. Kelsen explains that whether international law must be incorporated into national law before it can be applied depends on the constitutional provisions of the state. In some cases, international treaties or norms can be directly applied by national courts without any transformation into domestic law. However, when the Constitution requires it, international norms must be transposed into national statutes to become enforceable. This flexible approach to the application of international law reflects the varying relationships between national constitutions and international agreements, where some legal systems allow for direct application while others mandate legislative action. Quote 171. If the state organs are authorized to apply international law directly, the question arises what norm they have to apply if national and international law contradict one another. Kelsen addresses the potential conflict between national and international laws, particularly when national courts are empowered to apply international law directly. When contradictions arise between the two, the resolution depends on the specific legal framework of the state. Some constitutions may prioritize national law, even if it conflicts with international treaties, while others may grant precedence to international law. The handling of such conflicts highlights the complex relationship between the two systems, where constitutional provisions dictate how discrepancies are resolved, potentially leading to international delicts if national law violates international obligations. Quote 172. The pluralists regard national and international law as two systems of norms which are valid simultaneously, and they have to do so, since the international legal order is meaningless without the national legal order, and the legal existence of the state cannot be understood without taking into consideration the international law determining this existence. Kelsen critiques the pluralistic theory, which treats national and international law as separate but simultaneously valid systems. He argues that this approach is flawed because international law cannot function in isolation from national law, and the very existence of the state is shaped by international norms. National legal systems depend on international law to define their boundaries and obligations in the global context. By maintaining that both systems are valid together, pluralists overlook the interconnectedness of national and international law, which must be viewed as parts of a unified legal order to fully understand their mutual influence. Quote 173. The recognition of a community as a state is an act provided by positive international law. The recognition of international law by a state, as a recognition of its validity for that state, cannot possibly be an act anticipated by international law. Kelsen emphasizes that the recognition of a new state is a legal process governed by international law. However, he also points out that the recognition of international law itself by a state cannot be mandated by international law, as this would create a paradox. A state's recognition of international law is assumed within the international legal system, but the legal system itself cannot demand such recognition without first being valid. This highlights the inherent complexity in the relationship between state sovereignty and international legal obligations, where recognition operates as a fundamental principle for both statehood and the application of international norms. Quote 174. The thesis of the recognition theory, the primacy of national over international law, is only a juristic hypothesis, just like the opposite thesis, the primacy of international law. Kelsen discusses the competing theories of legal primacy, where one view holds that national law is supreme, and the other argues for the superiority of international law. He explains that both theories are hypothetical and cannot be definitively proven by legal science. Each perspective offers a different interpretation of the relationship between national and international law, with the choice between them often influenced by political or ideological preferences. These hypotheses shape how legal scholars and policymakers approach issues of sovereignty, international obligations, and the structure of legal systems, though neither can claim absolute validity. General Theory of Law and State by Hans Kelsen concludes by reinforcing the critical distinction between law and other normative systems such as morality or religion. Kelsen's pure theory posits that law must be understood as an autonomous system of norms, free from the influence of moral or political value judgments. By framing the state as a legal entity and emphasizing the hierarchical structure of norms, Kelsen leaves readers with a clear understanding of law as a complex but independent field, providing a stable foundation for both governance and the realization of social order. His insights continue to influence modern discussions on the role of law in society and the importance of maintaining a clear boundary between legal science and ideology.
Curious to dive into the mind of Hans Kelsen? With StudyLab Pro's Book GPT, it's possible. Ask questions, explore themes, and discover the depths of general theory of law and state in an entirely new way. Start your conversation now by clicking on our logo. And if you're hungry for more educational content, subscribe to our channel to keep discovering, learning, and growing. Want more than just videos? Click on our logo now to join us on our platform for multiple choice tests, in-depth content, and tools to help you ace your studies. Get started now.